Anne Dalzell.
This is what I would call a meaty part to the bill, and this is the one that I want to focus on. And I can't imagine that this will be over in an hour on this part, so I don't know why the Minister seems to think that it's going to pass so quickly. And I am going to table an amendment to this part that I would like the House to consider. And the Minister will not be surprised because, in fact, we referred to it in the report back version, the report back from the Labor members of the Select Committee, that we think that it's fundamentally important that there are principles to bind all financial markets participants. We were disappointed to see the securities review repeat, I think, some of the errors of the past, which is not to have a number of principles. And I think there was one overarching principle kind of mentioned at the end of the discussion document, which I felt was will be ineffective in terms of what we're trying to achieve here. So what I have done is I have gone to the Financial Markets Authority. I haven't tabled it yet. I've got plenty of time. But if somebody would like to assist me with that.
Let me assist.
All I've done is I've taken from the Financial Markets, the Financial Services Authority, rather, in the UK, the legislation that, well, it's not their legislation, it's actually the principles that they established under their conduct provisions. So they have authority under their legislation to issue statements of principle with respect to the conduct expected of approved persons. And when the authority does issue a statement of principle, it also is required to issue a code of practice for the purpose of helping to determine whether or not a person's conduct complies with the statement of principle. And the code then talks about specifying descriptions of the conduct, etc., that would be a breach of this code. And any failure to comply with a statement of principle, of course, does mean that there are issues that do need to be addressed. And the reason that I mention this, and I have mentioned this in the House before, so I'm going to mention it again because I think it was something that was a bit of a driver for me, but unfortunately too late for me to influence the securities legislation review. And the reason is that when I went back to the UK and met with the Financial Services Authority for a second time in my period as Minister, it was unfortunately in 2008. And it was at that time that I met the outgoing Chair, Sir Callum McCarthy, and I have told the story before. At the meeting that we had, he pulled from his pocket the laminated card with these set of principles. That's where I've got the principles from. And he told me that they were what guided him in all that he did, and that they were what guided the FSA and all that it did. And then he gave me his own personal laminated card. Now, he probably had dozens of them, but it was very effective because what that was for me was the indelible memory that I now have of that occasion, and when I realised for the first time that it was the enforceable principles that underpin rules that make the difference, because unlike rules, they are not made to be broken. And having come from the legal profession, and I know there are others in this House who've come from the accounting profession, and we know that our professions, our entire livelihoods are dependent on making the advice for people to get round rules, but principles can't be got round because they are something that actually guide everything that we do with integrity. So let's look at those principles that the FMA developed under their code. The first one is integrity. A firm must conduct its business with integrity. Skill, care and diligence. A firm must conduct its business with due skill, care and diligence. Management and control. A firm must take reasonable care to organise and control its affairs responsibly and effectively with adequate risk management systems. Financial prudence. A firm must maintain adequate financial resources. How useful that would have been as a principle to underpin certain activities of certain finance companies, Mr Chairman.
The Honourable Leanne Dalzell.
Mr Chairman, market conduct. A firm must observe proper standards of market conduct. Customers' interests. A firm must pay due regard to the interests of its customers and treat them fairly. Communications with customers. A firm must pay due regard to the information needs of its customers and communicate information to them in a way which is clear, fair and not misleading. And I will comment on one thing, because I know that the Minister's made some statements recently about the need perhaps to hold people personally accountable for statements that they've made in the public arena, you know, the sort of celebrity endorsements. I don't actually agree with that. I think we should prohibit them from doing it. I don't think we are not allowed, under current broadcasting standards, we are not allowed to have a doctor saying that a particular non-prescription drug is okay. It is actually prohibited because a doctor sends a very clear message. And I don't know about you, but I don't think that it is appropriate that there is a celebrity endorsement for a finance company that they can't possibly know whether they're actually up to delivering or not. And I don't think you punish the messenger. I think you just prevent that message being sent, because it's the wrong message to be sending. And I think that this is what this statement of principle that sits behind the Financial Services Authority in the UK is all about. We have to make sure that information is communicated in a way which is clear, fair and not misleading. Conflicts of interest. A firm must manage conflicts of interest fairly, both between itself and its customers and between one customer and another. We've talked about conflict of interest in relation to this bill. The chair of the Establishment Board, Simon Botherway, was in a situation which is now currently still before the Ombudsman, as I understand. But I want to just reflect on one element, because I personally think that I've taken a very strong line on conflicts of interest. And when I was Minister of Immigration, I made sure that my husband, who's a lawyer, did no immigration work at all, none, not one jot of immigration work, even though, of course, very few immigration cases actually end up in the Minister's hands. But it was the message that it sent that was wrong. But in this particular case, I think that I made a mistake in the House when I referred to the question of the South Canterbury Finance putting his brother's company into liquidation. As I understand it, or into receivership. As I understand it, it was Lion Breweries that put that company into receivership, and the South Canterbury Finance that then appointed its own receiver. So it is actually a step removed, and I do understand that the individual concerned took advice. And so I just want to put it on record that I accept his word for that, and that he acted honourably. I still believe he acted mistakenly, and that is a view that I will continue to hold, because I feel that conflicts of interest aren't just about real interests. They are about perceptions. And unfortunately, in this place, as we see all too often, perception is reality. But I did want to put that on the record. I agree with my position, but I don't agree with how I presented that. And I wish Simon Botherway well in his new career. Conflicts of customers' relationships of trust. A firm must take reasonable care to ensure the suitability of its advice and discretionary decisions for any customer who is entitled to rely upon its judgment. This is so fundamental. When you think about all of those people who went to a financial advisor expecting to get good, decent, quality advice about where they should put their money, and actually they were let down by a number of those people. Did they cross the legal line? Maybe not in particular cases, but they certainly would have crossed the line as far as this principle was concerned. Customers' assets. A firm must arrange adequate protection for customers' assets when it is responsible for them. And of course that should go without saying, but unfortunately it doesn't. go without saying, because adequate protection was not made in many instances in terms of the advice that people should have received. And then finally, relations with regulators. A firm must deal with its regulators in an open and cooperative way and must tell the FMA promptly anything relating to the firm of which the FMA would reasonably expect prompt notice. And the reason I really like that one is that it isn't, Mr Chairman.
I call the Honourable Leanne Dalziel.
Mr Chairman, the reason that I really like that particular principle is because what it does is it actually puts it back to the person who is the financial market participant to actually say, I'm going to deal with those that regulate my right to do this or undertake this activity in a reasonable way. I'm going to provide them with the information they need in order to ensure that the market itself has integrity. And that's what I think we are faced with at the moment, because we aren't talking about what really matters around these things. We have talked about in this legislation about their functions, the FMA's functions, to promote the confident and informed participation of businesses, investors and consumers in the financial markets. And that's actually quite an important objective. We want to promote and facilitate the development of fair, efficient and transparent financial markets. But there are two types of people out there, and we've written one law to cover both of them. And the two types of people are people who know that they take a risk when they invest their money. And there are other people out there who don't actually get that. They don't relate return to risk to return or anything like that. And I know that the answer to that in many respects is this question of financial literacy. But it's more than that. We should be able to trust people, to treat people honestly and with integrity. And unfortunately, the history of the finance company failures in this country says that there were people day in, day out who were prepared to rip off unsuspecting New Zealanders and take all of the benefit from it and none of the consequences for it. And I just think that that is unfair, and we have to make sure that we do better. We have let down the people of New Zealand in this place, not just from a party political point of view, because I think we can all look at each other, we can all look in the mirror and say that we all took a little too long to realise that people would take advantage of the lack of regulatory framework around the finance companies, and they did. There are other people within that frame, though, who didn't take advantage of other people. They genuinely screwed up their business model, and they made mistakes, but they made those mistakes with other people's money. And the question is, who pays, who carries the cost when things go horribly wrong? If these sets of principles were drummed into the hearts and minds of everyone who's out there fundraising off a sophisticated investor or an unsophisticated ma and pa investor, or whatever you want to call them, if these principles were just drummed into our everyday living and being, then how much better would it have been? How much money might we have seen saved and not seen lost in the debacle of the finance company failures? Our Select Committee is still considering its review of finance company failures. This legislation does bridge the gap in terms of some of the gaps that we've already identified, but it doesn't go far enough, and we know that there is the next item of legislation to come soon, but again I'm expressing some disappointment at what I've seen so far, and I also think that some of the gaps that we have identified need to be brought back to this House and debated when we report back on our review of the finance company failures, which I hope that we will be in a position to do so soon. I do apologise to the House that I wasn't in a position to present the amendment that I've now tabled in the House before now, but I've been somewhat focused on other matters over the last month, and I do appreciate and want to put on record my thanks to my colleagues for allowing me the time to spend with my constituents in Christchurch East over what has been a very difficult time. And I know that the challenges that we face in Christchurch East in terms of the recovery from the disaster that the two earthquakes have meted out on my electorate in particular, but other parts of Christchurch as well, in many respects, what I'm learning about recovery is something that we need to do in this area as well, because the recovery process for those that lost thousands and thousands of hard-earned dollars, their life savings in many instances, is something that actually hasn't been resolved. It hasn't been resolved by this government, and it's not resolved by the establishment of the Financial Markets Authority, except for one small element.